Welcome, everyone, to our Big Tent Spotlight tonight. For those of you who have not attended before, Big Tent was founded by a group of women in 2019 as a moderate political advocacy organization. We focus on protecting the rights of all Americans, civic engagement, and promoting smart and effective governance. Let's go to our guest tonight, who I am truly honored to introduce. Nancy Northup has served as president and CEO of the Center for Reproductive Rights since 2003. Under her leadership, the organization has become the global leader in using the power of law to advance reproductive rights as fundamental human rights. Prior to joining the center, Nancy was the founding director of the Democracy Program at the Brennan Center, where she litigated voting rights, campaign finance reform, and ballot access cases. Nancy, welcome and thank you.
Well, thank you so much. And I am so delighted to be invited tonight to speak to you at Big Tent. It is particularly heartening to see so many of you who are fighting every day to make sure that we preserve a vital and healthy democracy. And let me just start by just saying a little bit about the Center for Reproductive Rights. We were founded in 1992, so we're almost 30 years old. And our goal is to make sure that we advance reproductive rights as fundamental human rights, both here in the United States and around the world. So we're lawyers and human rights activists that make sure that women have access to the full range of reproductive health services, access to safe and legal abortion that we'll be talking about tonight, but also contraception, safe maternity care, access to assisted reproduction. And so all of these issues are intertwined in people's lives, and we work on all of them. We are nonpartisan, so we are a 501c3 only. We do not get involved in helping to support or oppose candidates or political parties for office. Our mission is to someday live in a world where you don't wake up the day after election and ask, are my rights still there? Because they'll be protected as fundamentally here in the United States as the right to free speech. So that is our goal, and I'm so delighted to be here today. I'm speaking to you from our headquarters in New York City. We also have an office in Washington, D.C., in Bogota, in Nairobi, in Geneva, and we work in all those areas around the world. And I also want to say one of the things that we do, in addition to building and enforcing and defending reproductive rights law, is that we catalyze others to join with us, which is particularly why I'm happy to be with you today. And one of the groups that we catalyze are attorneys. So in addition to our mighty staff of 200, we augment that with the donated services of over 800 lawyers around the world from 45 countries who are helping us to further that fight. So, know that it's not just our mighty crew, but we are joining hands with many, many lawyers, both in the United States and around the world. But I do want to talk to you tonight about the crisis that we're facing on abortion access here in the United States. I have been working on the issue of abortion rights from many different angles, going back to when I was a college student in Rhode Island. And I have never been as concerned about the protection for abortion access as I am today. The Center for Reproductive Rights is going to be arguing twice in the Supreme Court within the span of 30 days on abortion access issues. We're going to be arguing this coming Monday, so in just 5 days from now, in the Texas case, which I'm sure you've all heard about, and I'll talk about in a minute. And then we're going to be arguing on December the 1st in the case of Mississippi, in which the state of Mississippi has asked for Roe versus Wade to be overturned. And these two cases together, Texas is an example of how a state can use a very, very tricky legislation, I should say underhanded and sneaky, and basically trying to strip the courts of the ability to review their ban on abortion at 6 weeks and make it impossible on the ground before there's even a court decision. And then Mississippi raises the just direct question of should Roe be overturned. And in fact, as we look at Texas today, it's really been overturned in that state since September the 1st. So we will talk about that right now. And I'm going to start with Texas because we are arguing it in the Supreme Court on Monday. So back earlier this year, Texas passed a ban on abortion after 6 weeks. And they did so through a mechanism that a state hadn't done before. They, rather than say, we're going to enforce this as the state of Texas in our criminal code, which often is unfortunately how abortion is regulated, they said, we're going to have private citizens enforce this by creating a bounty hunter system where if they find out that someone has provided an abortion or aided and abetted anyone to have an abortion, that they can be sued civilly in Texas courts for a minimum $10,000 bounty, and they can have their attorney's fees paid for by those that they sue. So the provider or the person that drives them to the clinic could be a friend, could be a mom, and as well as putting the lawyers themselves exposed to both the attorney's fees being reversed on them. And they're just trying to make it very, very hard for people to actually be represented. But we are proudly, along with a whole coalition of groups who have sued, Planned Parenthood, the ACLU, the Center for Reproductive Rights as lead, the Lawyering Project, and others have come together on behalf of abortion providers, on behalf of staff that work at clinics, because they could be sued as aider and abettors, on behalf of members of the clergy, because in giving non-directive counsel to a woman, they could be charged with having aided and abetted her decision to have an abortion after 6 weeks. And we also in the lawsuit are the abortion funds. Unfortunately, as I'm sure you're all aware, in many, many states, Medicaid does not cover abortion services, despite the fact that the majority of women seeking abortion may be low income. And Texas is one of those states. So the funds raise private funds to help support women for both accessing abortion, but also for travel. And they have also joined the lawsuits to say that they themselves could be seen as aiders and abettors. So it's an incredible coalition that the center is proud to be leading counsel on. And what's happened that has brought us to the cusp of the Supreme Court argument on Monday is that we all sued back in July, 2 months before this law was to go into effect on September the 1st. And that's often what we do. We go into court early to say we want to get this law stopped before it can go into effect and wreak the harm that it does. And in many, many cases, we're able to do that. So that is what we did here. And in the district court, the trial court agreed with us that we could go forward with the lawsuit. And the state of Texas did what many defendants do in any lawsuit. It's very standard. You file something called a motion to dismiss, which just says, they can't even bring this case. And the district court denied that, as they should have, because we can sue against this unconstitutional law on behalf of these people who could be seen as aiders and abettors. And Texas ran up to the U.S. Court of Appeals for the Fifth Circuit, and they were able to get this district court's work on the case stopped. And we then ran up to the Supreme Court before this law was to go into effect on September 1st and said, please, you need to block what the Court of Appeals is doing, because we've got to get this injunction in the district court. And that is why, in a little middle of the night denial of our request to let us get back to the district court and seek an injunction, the Supreme Court turned its back on the people of Texas. And this law went into effect at midnight on the 1st of September. And I'm sure, as you've been following, that for now, almost 2 months, except for a very short period of 48 hours, people in Texas have not been able to get access to abortion after 6 weeks. And of course, most people may not even know that they're pregnant at 6 weeks. In fact, 85% of abortions in the state of Texas take place after 6 weeks. And it has been just a heart-wrenching circumstance in the state where clinics have had to turn away. I mean, their doors are open and they're seeing patients and they're providing abortions if they're as early as under 6 weeks. But mainly they're having to say to people, you need to leave the state to access a constitutional right. So that is a situation right now in Texas, that the constitutional right for more than 50 years to get access to abortion is being flat out denied by this tricky maneuver of the state of Texas. And I mentioned that there were 48 hours in which the clinics were able to open a couple weeks ago. And that is because the United States, the Department of Justice, entered and sued the state of Texas. And I want to emphasize how unprecedented this moment is, because that is something that the United States government, in the almost 50 years that abortion litigation has gone on, I mean, the Center for Reproductive Rights has litigated hundreds of cases, 80 cases just since, 2011. And these are all, cases of major import, 80 of them since in the last decade. But the United States has never entered before. But it is so bad right now that the Department of Justice sued the state of Texas and said, as the federal government, it is our obligation to defend the constitutional rights of the people in Texas. And we are coming in to do that. Absolutely extraordinary and unprecedented. And the district court was able to have a hearing in the United States case and issued an injunction and said the law needs to be stopped. And with it, the district court issued a 113-page opinion. And it is so detailed, it is so thorough, going through all of the legal arguments by Texas saying the US can't sue, but also really, really painting the picture of the tragedy on the ground right now in Texas as people are being turned away. Texas ran up to the US Court of Appeals for the Fifth Circuit, and that court stayed the injunction. They lifted the injunction in essence and said, we're gonna take the question of whether the United States can even sue or not. We had gone to the Supreme Court already a second time, saying, please just take this case for review. We don't need to wait to see what the Fifth Circuit does. We know what they're going to do. They've made it clear. And then the US government followed as soon as the injunction was stayed in that case. And they ran up to the Supreme Court and said, you need to decide this now. Again, don't wait for the Fifth Circuit. We know what they're going to do. And on Friday, just 5 days ago, the Supreme Court issued an order not still not stopping the law from being in effect, which is just shocking. And if you have any time to Google and read Justice Sotomayor's dissent from the fact that they didn't stop the law from being enforced, it's really, really powerful. She makes clear how outrageous it is that this is going on in the United States in 2021, that constitutional rights are just being flat out denied by a state against the federal government. But the Supreme Court did say, we're not going to stop the law. We're going to let you still have a law in effect, state of Texas, but we're going to have argument on this question about whether all these providers and advocates can sue, and we're going to decide whether the US government can sue. And we're going to have that hearing in the Supreme Court on Monday, the 1st of November. We asked for expedited review. We never thought it was going to be that fast. So Mark Herron, who's a lawyer for the Center for Reproductive Rights, who is the lead lawyer in this case, going to have just 10 days to put this together, and he'll be in the court arguing on Monday. And let me just pause here in case I forget to say, you can tune in. You can go to the Supreme Court's website. There are going to be no audience. No audience is going to be in the court on November the 1st or on December the 1st, except for the litigants who are arguing the case and the Supreme Court press. You can listen to it in real time on Monday at 10 a.m. Eastern. So I hope that you will. And you can listen to the US government's case at 11 o'clock Eastern. And I hope that you will, and encourage others to sign in. So that's happening. And again, they're not going to be deciding whether Roe versus Wade should be overturned on Monday. They're going to decide whether the United States government, in its case, and the providers in our case, can go forward with the lawsuits that we have brought. And let me just say one more thing about the legal complexities here. One of the reasons that they made it so hard to sue is because they have put this incredible liability on doctors who provide services, and then made it very hard because of the onerous penalties to represent them and defend them. But again, we are doing that. Many other lawyers are doing that. And it's very hard for the doctors to violate this clearly unconstitutional ban, because the law says that even if an injunction is in place and you provide services and that's later lifted, that a bunch of people can come and sue you. There's unlimited number of people who can sue you. They don't have to live in the state of Texas. They don't have to have any connection with the lawsuit. And one of our clients, Dr. Braid, went ahead and did provide an abortion for a woman who was in the first trimester, but it was after 6 weeks. And then he wrote an op-ed about it in the Washington Post, in which he talked about why, as a physician, he gave care to his patients, because this is what he has been an OBGYN for almost 50 years. And he is absolutely heartbroken about the fact that usually he can meet with a woman and give her options. And right now, he can't do that. He cannot practice medicine to help and care for his patients. So he's been sued by someone in Illinois, someone in Arkansas, somebody in Texas. And we're also defending Dr. Braid in those lawsuits in state court. And we also filed another lawsuit in federal court saying, put all these together. So there's a lot of legal stuff going on, but the big show right now is next Monday in the Supreme Court. And now let me turn to talking about the case out of Mississippi, Jackson Women's Health Organization versus Dobbs. Mississippi passed a ban on abortion at 15 weeks. They've also passed bans at 6 weeks. They've done it all, but this is the one that they actually tried to put into effect. So we sued, representing the last abortion clinic in the state of Mississippi, Jackson Women's Health Organization in Jackson, Mississippi. If you follow the press at all, you may have seen stories about them over the years. They're so clear that they're not going anywhere that they painted the clinic bright pink to send the message, we're not hiding, we're here to stay. And they have been the only clinic in Mississippi now for over a decade. And they provide care to women in that state. And so they're plaintiffs in the lawsuit. We got it easily struck down in the district court, as we should. And I'll talk about Roe versus Wade in just a moment. What is the law that's at stake here? But Roe has been very clear, and every case since, that you cannot ultimately deny the woman the choice before fetal viability. 15 weeks is way before fetal viability. So we won the district court. But even though it was such an easy case in the district court judge wrote a very compelling decision, because he talked about how this law smacked of the old Mississippi, in his words, and how the old Mississippi that was bent on controlling women and minorities. And he mentioned that in the case because he wanted to make clear that the impact in Mississippi falls hardest on women of color, particularly African-American women in the state, and particularly people of low income. Mississippi ranks at the bottom of the United States in maternal health and child health, and in people living in poverty. And the judge wanted to make that clear. And the judge also made clear, and these are his words, that the state of Mississippi's pretense that this law is somehow about women's health, he called pure gaslighting. So very strong, very thorough opinion, again, by a district court that's close to the ground and seeing what's happening, goes up to the U.S. Court of Appeals, Fifth Circuit, and even that very conservative circuit court said it's clearly unconstitutional under Roe versus Wade. And so they upheld the law being struck down. And then Mississippi took it to the Supreme Court, hoping with the change of composition of that court, that they would be able to get review of the case. And in a really shocking moment, the Supreme Court granted review last May. And they granted review on the question of whether this was constitutional, which it clearly is not under Roe versus Wade. And the state of Mississippi, in filing its brief last summer, despite the fact that they tried to be a little underhanded about the fact they were going for the gold in terms of reversing Roe versus Wade, their brief, they came in roaring, saying that the Supreme Court should overturn Roe versus Wade, that the Supreme Court should also overturn Planned Parenthood versus Casey and every other case, basically granting any kind of abortion rights in the last 49 years. So that is what is at stake on the 1st of December. And we are going to be Julie Rickelman of our team, who argued and won the June medical decision out of Louisiana just 15 months ago. We'll be arguing that again. And we're framing our argument to the court around 3 basic themes. The strongest one, because we need to get justices on the court, like Chief Justice Roberts, Justice Kavanaugh, justices who do not agree with us that the Constitution protects a fundamental right to abortion. We need their votes because we need 5. And so we are stressing very hard, which is absolutely the case, that the rule of law, integrity of the court, the very concept of precedent, and in this case, precedent upon precedent, dictates that the court needs to render the decision for us. And in fact, it's what Chief Justice Roberts did in the June medical decision of 2020. He disagreed with us on the merits. He voted the other way in 2016 in a case called Whole Women's Health. But he voted with us because the precedent had been established just 4 years earlier. Well, now we're going 49 years. So we're making that argument about precedent upon precedent, integrity of the court. We're also arguing the merits of it, which is that this is a fundamental issue of gender equality. And the court made that clear in its decision in Planned Parenthood versus Casey when it said that women's ability to control their reproductive life has what has enabled them to fully participate in the social, economic, and political life of the nation. And so that strain is also there. And the third point that we're making in the case, the state of Mississippi has argued that somehow, if they just reverse Roe versus Wade, it'll settle the very contentious issue of abortion in the United States. And we make the point that, in fact, it would be absolute chaos. And of course, when we filed our brief, we didn't know what the situation would be in Texas, but it certainly makes it clear the kind of chaos we're seeing, with people having to cross state lines, with clinics in other states being overwhelmed. And so we want to make clear that turning their back on Roe versus Wade is not going to settle the issue of abortion in American politics. It's going to intensify it. So that's up for December 1st. And let me just, before we open up to questions, just say, kind of 2 more things. One is to make sure that all of you, those of you of lawyers who may have read the case of Roe versus Wade, or if not, may have studied it in school, basically what the case, in 1973 said, and I will also note that it came out of the state of Texas. Jane Roe was a woman who lived in the state of Texas, and they had a criminal ban on abortion, except for to save a woman's life. And that went up to the Supreme Court in 1973. And the court said that the protections of the Constitution's Liberty Clause in the 14th Amendment, that protects the liberty interest of the woman in making a decision whether to continue with a pregnancy. And as I said before, that before fetal viability, that decision ultimately cannot be taken away from her. And in Planned Parenthood versus Casey in 1992, the Supreme Court did a whole review again of whether or not to overturn Roe versus Wade. They were being asked to do so. And after reviewing all of the arguments again, after reviewing all of the questions that are before the court today, 30 years later, again, including about the line of viability being the constitutional line that the court drew, it again said that they were affirming the fundamental right of the woman to make the decision prior to viability. And so that's why we talk about precedent on top of precedent, because it's not just the precedent of Roe in 49 years, which would be a hell of a lot, but it is also the court looking at it again almost 30 years ago and saying, you know what, this has worked. It is worked both for women in terms of gender equality, and it's worked as a matter of law because there is a line drawn and it's clear. And so we are reaffirming it. So that is that in a nutshell. And the final thing that I will say before we get to questions is, this is not just, neither case is just an issue of abortion rights. It really, when we think about the fundamental principle of Roe itself, it rests on 50 years of court decisions about what the court in Planned Parenthood versus Casey called a realm of personal liberty that the government can't enter. And in that realm of personal liberty, going back 50 years, are issues about how we raise our families, about who we marry. And the cases going 50 years beyond that are also issues about our families, about who we marry, and more. It is all the most personal decisions of a person's life. So what is at stake here is not just abortion, but the whole category of very highly personal family issues, the most important issues in many of our lives. And in the Texas case, what's on the line is not just whether abortion rights can be subverted, right? Whether a state can actually nullify the federal constitution, something that we thought we fought a whole civil war over, but they can nullify it. It's not limited to abortion rights. It could be done for any other issues, First Amendment, voting, marriage equality, or even there is a gun rights group that filed a brief on our side in the Supreme Court in this case to say what is being done to abortion rights could be done to gun rights. And it's a legitimate brief by a legitimate gun rights Second Amendment group because they're being represented in the Supreme Court by a team of lawyers who we often litigate against. They are not supporters of abortion rights. They're opponents of it, but even they see how dangerous the Texas case is. So these cases have a lot at stake for every single person in the United States. So with that, I hope I've given you a little summary of what's happening in the Supreme Court, both Monday and then on December the 1st. I think we're going to open it up to questions.
Yeah, we have several really excellent questions. Carmina Roth asks, should the conservative majority attempt to prevail, or what precedent do you think they will rely on?
You know, they don't have any precedent to rely on. They would have to do what Justice Thomas has wanted to do, you know, for as soon as he rendered his first Supreme Court opinion on abortion rights, after testifying at his hearing that he'd never considered the issue of whether Roe versus Wade was well grounded in the Constitution, never considered it, never discussed it. So he testified to. In the first decision, he came roaring in dissent, saying Roe versus Wade was wrongly decided and should be overturned. They're going to have to say Roe versus Wade was wrongly decided and should be overturned. There's no principled basis for them to make some distinction in the Mississippi case. The precedent, as I've just gone over, is clear. They've reaffirmed it again and again, including as recently as this is Monday will be our 4th case in the Supreme Court in 5.5 years. December 1st will be our 5th case. They've reaffirmed it again and again and again. So all they can do is say, we don't agree that it was rightly decided, which is a way of saying precedent doesn't matter. And we're going to overthrow precedent that is almost 50 years old.
Another question from Kitty Douglas. Will the case against Dr. Baird overturn any elements of SB 8 and upcoming Florida law? What will CFRR use as precedent to argue the case?
So the case, Dr. Braid is now defending in state court in Texas, being sued under SB 8 by plaintiffs looking for the $10,000 bounty and their attorney's fees if they seek them. And so in defending Dr. Braid in state court, you know, we are arguing that the law is unconstitutional. So we expect to be able to get that ruling that the law is unconstitutional and should be blocked from people suing Dr. Braid, and then would be arguing that it should be more broadly applied. So that is how that resolution can ultimately affect more than just Dr. Braid.
I have a question. I'm curious as to what you think the center's most important wins or win, and what was the most important loss that you've had over the years?
It's a great question. And I'm actually looking at, we still have I also want to recognize that Cynthia Blumenthal, I think, is on the call tonight, and she's a board member of the Center for Reproductive Rights. And so she's used to seeing our win-loss record, which is pretty strong. Even with all the change in the federal courts during the Trump years, we still are running at like a 70% win rate. The most important victory in, you know, there haven't been, it's got to be well, I'm going to give you one in state court, and I'm going to give you one in federal court. As you all know, in our country, we have state constitutions that protect our rights, differ among the 50 states. They're all different. And then we have the federal constitution. And one of the most heartening wins that we have had was a few years ago in the Kansas Supreme Court. And we were litigating against abortion restrictions in that state. And the Kansas Supreme Court issued a decision that access to abortion is protected under the Kansas Constitution more strongly than it is under the US Constitution. So we haven't had the time tonight to get into the current standard of abortion review, which is the undue burden standard in the Supreme Court. But what Kansas said is the strictest level of review would be made by the Kansas Supreme Court. And in rendering that decision, it was fantastic because it was a very long decision, well over 100 pages. And they went through everything from, the founding of Kansas to the Magna Carta to like cited Abraham Lincoln, like everything under the sun, to analyze what did Kansas mean when it was doing its, constitution. So that is it was a proud victory, an incredibly important victory to show that you can have even stronger protections in the US Constitution. So I would say that would be one of them that I would pick in the state court system. And in federal court, I do think it's the decision that we won in 2016 in Whole Women's Health versus Hellerstedt. We and other organizations, Planned Parenthood, ACLU, other organizations, our litigating partners, have been fighting against these targeted regulation of abortion providers for, a couple decades. And these are when states would pass laws that would purport to advance women's health, but they actually were just designed to close clinics or make it very difficult to stay in practice. And Texas passed two laws, one which said that all abortion provision must be done in ambulatory surgical centers, which is completely absurd, right? We had the AMA coming in saying, this is an incredibly safe procedure that in the first trimester can be done in doctors' offices. The state of Texas was saying to take the abortion pill, you had to go into an ambulatory surgical center. And so that closed half the clinics in Texas. And even though we ultimately won the issue, many of the clinics stayed closed. But there's that, and there was also the issue of admitting privileges, saying that doctors had to have admitting privileges in local hospitals. And of course, because abortion is such a safe procedure, abortion providers don't admit patients to hospitals, unless they also have an obstetrics care and are delivering babies, in which case they have admitting privileges. And so this was just designed to bar a lot of doctors from being able to provide abortion services in Texas. And again, it was having the effect of closing clinics. And it was if these targeted regulations of abortion providers had been allowed to stand, I said that the clinics, Texas would have been down to something like 9 clinics, right? And it would have been used in other states as it already had been pushed. So that was a big turning point to have been able to have the court reaffirm that when it came to the regulation of abortion, you had to actually show that the provisions advanced women's health. The state of Texas couldn't just say it, but it was clearly not true. And that was so important because it was like we were in just a ton of these lawsuits that were having a real negative effect. But it was just like gaslighting. They would come into court and say, well, we just think it would be better if, everybody had admitting privileges. And I'll never forget Justice Kagan's question at the oral argument where she asked the state of Texas, well, she said, Mass General is the best hospital in the United States, being a person from many years of living in Massachusetts. She said, Mass General is the best hospital in the United States. Could we require that all abortions be done at Mass General? Some marginal improvement on women's health. So that was, I think I would say that was really, really important to have been able to pull that out of the Supreme Court in 2016.
And your worst loss?
Oh. I mean, we've lost cases that have had, that have definitely had marginal impacts. Like it has been frustrating to have lost, some of the mandatory waiting period cases. But, the biggest loss comes when we won a case under Florida state constitution, and then they turned around and amended the constitution to take away the right. In fact, the decision in Kansas, which is so strong on the ballot in 2022 in the state of Kansas, is going to be taking the protection of abortion rights out of their constitution, which would be a big loss. But I can't, we lost in the Supreme Court on the so-called Partial Birth Abortion Act cases. And that is, deeply unfortunate that we now have a federal criminal statute. I used to be a federal prosecutor in the U.S. Attorney's Office in the Southern District of New York. The idea that you could bring the weight of federal prosecution on a doctor about the safe, approved procedure to perform an abortion, I think is stunning. So that was a reversal of a win that we'd had in the Supreme Court in 2000. Court reversed itself in 2007. So, that was the only big loss in the Supreme Court since our founding in 1992.
Someone is asking, Mary Himes is asking, are there examples of the court overturning precedent?
Well, yes. But the examples that we think of are in rights protective direction. So the court eventually overturned Plessy versus Ferguson,
right?
And separate but equal in Brown versus Board of Education, but they were overturning a wrong interpretation of the Constitution instead of, in terms of the protection of individual rights. You think about the court overturned its decision in 1987. It decided a case called Bowers versus Hardwick, in which they said states could criminalize homosexual consensual sexual activity. And they overturned that in Lawrence versus Texas in 2003 to say it was wrong. But again, in these cases, they're examples of individual liberties, the right to equal treatment, the right to, when I talked about that zone of personal liberty that the government cannot enter, that Lawrence versus Texas, the 2003 case that reversed Bowers versus Hardwick and said the government cannot make it a crime to be gay, that rests on Planned Parenthood versus Casey. That is really the major site in that decision. So the court has done that, and obviously in other, in other statutory cases. But what is unprecedented is the court saying we've recognized a right, but now we're going to say that we're wrong, and we're going to decrease your individual liberties because we were wrong to have decided it that way.
And if they overturn Roe, what happens to the state constitutions that do codify a woman's right to choose?
Right. So it doesn't affect them at all. I mean, the only way, and the court's not going to do this, the only way that they could have supremacy over states that protect abortion rights is if the court were to recognize that under the Constitution, under the 14th Amendment, a person has constitutional rights from the moment of conception. That argument was also made and rejected in Planned Parenthood versus Casey. The court's not going to decide that because it's unmanageable, right? To decide that an embryo is a person with full constitutional rights. There are probably some on the court that'd like to, but many others on the court are not going to go in that direction. They're just going to say that, Roe was wrongly decided. This is an issue for the states to decide. We don't need to decide it. So the state constitutions that exist or statutes, right? You can protect rights in statutes or you can protect them in constitutions or both. California does both. New York does it in its statute. So about half the states would be protective, but about half the states would not. We've been publishing, and you can go to our website, we've been publishing a report called What If Roe Fell since the Bush administration, when there was real concern about the court overturning Roe. I mean, the concerns have been real every step of the way. They're just super real where we stand today. But we've been publishing that, and it shows you that there is a huge swath of the nation in which they already have trigger laws in place. So they've already said it's a matter of state policy that they'll reverse Roe they will reinstitute criminal abortion bans if Roe is reversed. There are some states that are clear that it is the policy of the state to protect life from the moment of conception in their state constitutions. So those states would criminalize abortion. And there are others that are both the state House and the state Senate and the governor are anti-abortion rights, and we would assume they would move quickly to legislate. So we look at about half the states as being poised to recriminalize abortion. It's vast swaths of the South and vast swaths of the Midwest. But what can be done is already referenced to. So we will go into court and we will fight trigger bans from going back into effect. We will go into court and we will fight against new bans, either under state constitutions where we can, and depending on how the court decides, if there's something left to sue under federal court, we will. But ultimately, and so there will be that vigorous work done. We'll also be working with allies and hopefully many of you around the country to strengthen protections where they can be, because we've got to make sure that states do lock it into the constitutions while they can, when they have supportive abortion rights in their House and their Senate and their governors, lest there be a change in that political balance with a forward administration. You want to get that into the Constitution through initiative or in some places through legislation. Ultimately, we have got to have federal statutory protection for access to abortion. And that bill already exists. It's the Women's Health Protection Act. Senator Blumenthal has been the lead sponsor of that bill in the Senate since it was first introduced in 2013. It passed the House after the Supreme Court turned its back. So it passed the House in September, and it's strongly supported by the Biden administration. We are ultimately going to have federal legislation because unfortunately there are states, Texas, Mississippi, Alabama, Louisiana, Arkansas, I could go on, that are not going to protect it in their state statutes. They're not going to protect it in their state court system or in their constitution. And the only protection needs to ultimately come from the United States government. Congress has the power, the ability to fix this right now. And so I think one of the things that is really important is that people start educating themselves about that fact, and that we all work until it's done, until that work is done, until the Women's Health Protection Act is passed. It's protected under federal statute, and it gives the Department of Justice, as well as people like the Center for Reproductive Rights, the ability to sue states and get much straightforward protection against this whole litany of restrictions that have made access so difficult.
A number of people are interested in the difference between the legal team at Planned Parenthood versus you guys and how you're different. I know you work together quite a bit, but if you could address that.
Sure. We absolutely do work together. The litigating organizations are constantly talking with each other, sharing ideas, sharing strategies, preparing for cases, preparing each other for argument. Planned Parenthood attorneys, ACLU attorneys, and attorneys in the private bar who are SCOTUS experts will all be mooting Mark between today and Monday before he argues. The same thing with Julie. Planned Parenthood represents its own clinics in abortion rights cases. So it's like the New York Times representing itself, right, in a First Amendment case. And the center represents other parties. We represent independent clinics. So Whole Women's Health in the 2016 case and in the case in Texas right now, and Dr. Braid and other clinics that are called independent providers. They can be doctors' practices or they can be, freestanding clinics. Jackson Women's Health Organization, freestanding clinic in Jackson, Mississippi. So the difference is Planned Parenthood representing its own clinics, and we're representing independent clinics and sometimes other parties as well.
There are several people who are asking, what can they do? Should they show up on the steps of the Supreme Court? Yes. Okay.
Yes, but there's a ton of things you can do. I mean, we're in the fight. This is it. This is it. And again, if you'd ever told me that when I was wandering the halls of the Rhode Island legislature, when I was in college talking about abortion rights, that we would be at this moment today, I would never have believed it. But we are at this moment, and it's going to take every single person to show their support. So I would say, yes, you can show up on Monday in front of the Supreme Court. You can plan to go down on December the 1st. There will be a full scale, people will be in front of the court on Monday. On December 1st, there'll be a full scale rally going on, all the hours of which the argument is happening. And it'll be important to have a really big showing then. The thing that I always tell people is the most important thing to do is be visible in your support for abortion rights, for reproductive rights generally. Be visible in your spheres of influence, right? People are influenced by people that they know, people that they trust, people who they care to hear from. So, you know, your family, your religious community, if you have one, your span of influence, if you happen to be a business owner or business leader, that span of influence, your clubs, your associations, however you can, to let people know there's so much stigma. There still is so much stigma around abortion rights, but just being, you know, forthright about, I support abortion rights, but also why you do, right? Why is it meaningful to you? It might be a personal experience with yourself, a friend, a family member. It might be because of your religious upbringing and you're valuing the inherent dignity and worth of every person. It could be from your work with, you know, teens. It could be whatever it is for you. And to talk about that, and to not, the thing that's really, really important is to talk about what's important to you. Don't tell someone else what to think. Nobody wants to be told what to think. You know, one of the things that in the Irish abortion referendum campaign in 2018 were fantastic campaign run to finally remove from the Irish Constitution the ban on abortion. It was done in a national referendum. We had been involved in previous litigation showing that the Irish ban was a violation of human rights. And in that campaign, the thing that they were really clear about was not telling people what to think. And to be clear about that, every person who's going out to knock on a door, to talk to people at a meeting, was to speak from their own experience and to trust that people will come to their own conclusions. And the theme of that campaign, it was called Together for Yes, vote yes on the referendum. The theme of that campaign was a woman you love may need your vote. And they just kept it simple and personal. So I always say, you have a sphere of influence and think about it and then use it. I mean, that's what, you know, in the Supreme Court this time, there were 50 friend of the court briefs filed in support of the clinic in Mississippi in our case. And one of them was by athletes. We had the WNBA, the Women's National Basketball Players Association, filed a brief in the Supreme Court saying that they wanted Roe versus Wade protected. The National Women's Soccer League Players Association, you know, a lot of leading soccer players. We had Olympians. We had people, high school athletes, college athletes. We had people coming out saying, this is important to me. And I'm going to use the platform that I had in that case as an athlete and as a professional athlete, as an Olympian, to say, this is why it matters to me. So that is super important. You also need to help support passage of the Women's Health Protection Act. There are 48 senators who are co-sponsors of the act. Obviously more needed to get it over the line, but get involved. You can find out on the Act for Women campaign site what's happening there, but do be super vocal about that. Talk to people about it, educate people. Again, use your platforms around that. And obviously, you know, be supportive as you can of organizations, whether it's those working in the courts, those working to elect candidates. Again, we don't do that work. Important people do that work to help support candidates who support abortion rights, supporting the abortion fund, supporting the, you know, local groups on the ground, all of it. So just really, this is the time to be out there, to be clear about where you stand, because you just think about what Dr. Bray did in that Washington, you know, op-ed. He just felt like, this is what I can do. This is my platform, is to say, I'm just a doctor trying to serve my patients. And I'm going to be out there on this because it's needed now.
If you had a crystal ball, one of the questions is, how are you predicting each Supreme Court justice to rule on this case?
I'm only going to predict the ones that I am crystal clear about. You know, we know that the Justice Breyer and Justice Sotomayor and Justice Kagan support abortion rights. They were clear about that in the whole women's health case in 2016, in the June medical case in 2020. They were clear about that they would have granted an injunction in this case, and they all wrote opinions when the Supreme Court didn't take that action. So we know where they will be. We know that, you know, Justice Thomas has been clear he wants Roe versus Wade overturned. Justice Gorsuch, Justice Alito, they are all in that camp. So I think we can be pretty sure. Justice Amy Coney Barrett, we've never had on the Supreme Court. So we've had people on the Supreme Court who were critics of the legal decision in Roe versus Wade, critics of the constitutional analysis there. We've never had someone, but we do now with Amy Coney Barrett, who was an activist against abortion rights. I mean, she signed letters, she signed ads that took the substantive position that abortion should not be legal. So I think we know where she's going to stand on that. So, you know, really it's a matter of, again, Chief Justice Roberts voted on precedent in the 2020 case. And Justice Kavanaugh is going to have to make a decision whether he's going to uphold the integrity of the court and precedent to vote with us in this case.
If they overturn Roe, God forbid, and I'm an atheist, but would you support increasing the number of justices on the court?
That is not something from the Center for Reproductive Rights would have to take a look at that very carefully. It's not something that we have done or we have a position on or that we're advocating on. So I think that is, you know, the President Biden has a commission now. It came up as an issue during the campaign. He has a commission that's looking at the issue. As someone who's spent, you know, my life and career as a lawyer dedicated to the rule of law, I have a fundamental respect for the Supreme Court. I'd want to hear from that commission on what they, and I know our board would want to hear from that commission on what they think are the merits and downsides of taking that kind of political stance against the Supreme Court. You know, so that's, we don't have a position on it. And let's hope it doesn't get to the point where we need to consider it.
Well, we're coming to a close. I personally would just love, this was just fabulous, Nancy. Thank you for an incredible evening. I believe it's safe to bet that everyone here on this chat and in this group are not personally affected. We all have the resources to obtain an abortion, but it's imperative that we protect the community of women who are at ground zero with these new laws. No one needs to be reminded they have us and our daughters in their sights as well. Thank you all for coming, and we look forward to seeing you at our next event. Thank you again, Nancy.
Thank you so much.